Greetings, great brethren. How are you doing today? Hope all is well. So today we're going to get into part two. All right, let's pull that up in a second. Where's it at? It is right there. Okay. Okay, so we're going back to, I think we're on page 15. Let me see. Yeah, I think we were on 15. I'm not sure. Yep. So let's scroll down to 15. We'll pick up from there. So, great brethren, how are you doing today? Hope all is well. I know this is some of you guys are watching your alumni playing football today, so that's why we're going to keep this simple. So you can mute the volume and you can listen to this, because at the end of the day, who really wants to listen to the broadcasters? Unless it's Gus Johnson. I'll listen to him. Other than that, I'm not really listening. So we only know about misconduct that is reported in documents we can obtain. Okay, so I believe we stop right there. So black murder exonerees spend longer before release than white murder exonerees, about 16 years on average compared to about 13, or they were sentenced to death. 3 additional years in prison is a severe penalty. I agree. I concur. So, for reference, average total time spent in prison for drug crime exonerees is about 1 year, excluding those who serve no time because they got probation. It's still under 2 years. The longer pipeline to exonerations also mean that at any given time, a larger proportion of black murder defendants who will eventually be exonerated are still in prison. Ooh, yeah, that's brutal. Very brutal. Turn that down a little bit. Okay, so getting back into it. Murder exonerations with known misconduct do take longer than those without. So you hear that, guys? So when you have police misconduct, it's going to take longer because they're going to back their misconduct. 17.7 years to 12.2 years on average. The higher rate of, and that's also to prosecutors who are just trying to get their percentages, okay, who are trying to move up the rank and file. We call that hirelings because they're trying to move up into different positions, et cetera, et cetera, et cetera. And hirelings is referenced in numerous books. One is The Miseducation of the Negro. So go check that book out. The longer time to resist, okay, to resist exonerations more strenuously in cases with government misconduct. The longer time to exonerate for black exonerees may also contribute to the higher rate known misconduct because it provides better opportunity for misconduct that occurred to be discovered. In any event, differences in time to exoneration by race persist even after control for government misconduct. Among murder exonerations with official misconduct, the average time to exoneration is 19.1 years for black exonerees and 16.6 years for white exonerees. Among murder exonerations without misconduct is 13.3. Black exonerees is 11.3. No, 11.3 for white, excuse me. It seems that innocent black men, let's just say men, who are convicted of murder are at a disadvantage not only because of their convictions, but more likely to have been influenced by official misconduct, also simply because of their race. Okay. In 1984, 19-year-old Henry McCullen and his 15-year-old half-brother Leon Brown were sentenced to death for the rape and murder of 11-year-old Sabrina Bree of Robeson County, North Carolina. McCullen and Brown were from New Jersey. They were visiting relatives in North Carolina. Both were intellectually disabled and both falsely confessed under pressure from police. That's why you should have a lawyer present anytime you're being questioned by police. No physical evidence connected them to the crime. This is before the preponderance of evidence being put on DNA. And in 2010, after decades of unsuccessful efforts to prove their innocence through the courts, the North Carolina Innocence Inquiry Commission, agreed to investigate the case. It determined that DNA from a cigarette butt found at the scene of the crime from Roscoe Artis. Come on, man. Roscoe, a proven serial murderer and rapist who was himself sentenced to death for raping and killing an 18-year-old woman in the same county about a month after McCullen and Brown had confessed. Artis has been suspected in the Sabrina Brew rape murder. In 1984, the police had asked North Carolina State Bureau of Investigations to compare fingerprints found on beer cans and crime. Why are these guys always leaving stuff around? But they hid that request from the defense. The authorities also concealed the fact that the witness who testified at trial when McCullen and Brown had admitted to the murder. McCullen and Brown were exonerated in 2000. Whoa, that's 20 years. That's 30 years. Whoa. And after nearly 31 years in prison, that's what I said. They pardoned by the governor of North Carolina in 2015 and received $750,000 each. That's it. Even so, after the release, the prosecutor who sent them to death row told the New York Times, no question about it, absolutely they were guilty. Who was that? Who was that prosecutor at that time? I gotta know. They don't put the prosecutor's name on it. Why? All right, certainly there was misconduct that contributed to the conviction of McCullen and Brown, and that may have contributed to decades of resistance to reopen their case. Did it also matter that defendants were black, as well as strangers to the community and intellectually disabled? Did their race contribute to the authorities' unjustified and apparent examination, confidence in the guilty, even as evidence of innocence mounted? That would fit the data we see around cases. Changes over time. We can't date an exoneration in at least two ways. The conventional one is by date. The exoneration itself occurred, the occasion which the defendant was finally cleared. This sorting describes the timing and process of exoneration innocent defendants. Figure 1, for example, shows the annual number of murder exonerations has been growing pretty steady since 1989. Here's a chart. Yeah, so it just keeps on growing, which means that you had a lot of malfeasance and a lot of false incarcerations if you're looking at that chart right there. Okay, had a spike in 2001. And then you got to understand from 96, you had the 2-strike rule, 96, 97. With Bill Clinton actually signed in after he actually got in trouble with having sexual affairs with Monica Lewinsky. He actually teamed up with the Republicans and Democrats too. They proposed that bill for the 2 strikes rule. So you start seeing escalation in defendants that actually were being incarcerated at that point, sometimes unjustifiably. Boom. So right before Bush got in office, right there in 2000, you start seeing the steady rise, starting from Bill Clinton all the way to Bush. All right. And then it tapered down just a little bit and it went right back up. You notice you have a steady ascension of exonerations once Obama was in office, because a lot of these guys were in prison right at this point, but they don't show it down on the chart. In order to study the process that led to the innocent defendant's conviction, however, we need to focus on the period leading up to the event and classify exonerations by date of conviction. It shows the date of convictions are more spread out than dates of exonerations. They range from 56 to 2019. They rise sharp from 92 to 90. Remember I told you, Clinton, Democrats, 2 strikes rules, heavier penalties for powder cocaine really in the 80s, if you go 89, to crack cocaine, and that's when you see the rise. But let's see, what's the second chart says? Number of murder exonerations by year of conviction. Right during the crack era. So you start seeing the peak go up during the crack era. Boom. It stopped right around 96, 98, and you see it taper down. A major reason for the drop-off of exonerations and convictions after the mid-90s in the time, which averages 16.2 years for murder exonerations. As a result, many exonerations that will eventually happen for murder convictions after 1995 may not have yet occurred, including some of the cases that are already more than 25 years after conviction. Wow. Whew. The all-time high watermark in the number of murders in the United States lasted from 90 to 94, with convictions trailing by 1 to a few years. If we separate out homicide exonerations by race and defendant, we see black murder exonerees than white for all a handful of years of convictions, despite the fact that black people are a small minority of the population. The disparity in concentrated and accounts for the largest number of cases in the period from 92 to 2000, the years for which the number of all murder exonerations is the highest. So you had a lot of people being falsely charged for drugs, and I think that the link actually connects to drugs and murder. But hey, let's look at what the charts say. Boom. Boom. Okay. Figure 4 displays a running. Okay, go down. Hold on. Go down. Not that far. Figure 4 displays a running 5-year average of percentage of murder exonerations with black exonerees by year of conviction. The proportion has remained fairly stable since 80, ranging back and forth from 45 to 61, between 3.5 and 4.5 times the proportion of black people in the population. Okay. All right. Okay. Percentage of murder exonerations with black defendants by year of conviction. Okay. On the other hand, there's been a large and reasonably steady increase in the proportion of black murder exonerees by year of exoneration, from 37% in 91 to 66% in 2020, as we see in figure 5. Okay. So they said that was from 91. Okay, it was 91. Okay. So these are individuals being exonerated for murder. And these are black. Why don't they just say black men? Because the majority of the people exonerated are actually black men, because the majority of those incarcerated unjustly are black men. Why has there been a sharp increase of the percentage of black murder exonerations by year of exoneration since 91? That's a good question. What do they say in this paper? The answer turns out so on two other patterns. First, we saw in the previous section, black murder exonerees spend on average 3 years longer in prison before exonerations than white murder exonerees. Second, as we see in figure 6, the average time spent in prison for all murder exonerees nearly tripled over the same period, from less than 7 years to those cleared in 91 to 19 years for those exonerees in 2000. Wow. Okay, where's the chart at? Oh, there it is. So this is the figure, years in prison before murder exonerees by year of exoneration, 5-year moving average. Okay. It keeps on going up. So the rate of exoneration innocent murder defendants has picked up steam in a spurt since 89, rising from about 16 a year in basically in 2006, University of Michigan.edu/law. This isn't in the paper, but this is straight from the memory. You had 320 people. That was in 2006. So they would choose a small sample of individuals. And like I said, it was 16 a year, all the way from 89 to 1993. So by 91, you only had 32. By 93, you had 64. That's it. They didn't really want to tackle many of those cases because they were getting labor from those individuals. And then they start their private contracting for prisons around this point, where they had shareholders that would invest in. So they needed to have bodies in prison. So they were very slow to, and it says to 69 murder exonerations a year for the most recent 5-year period. See figure 1. Okay, so for the most part, that's all you had was 320 in 2006, 320. And now you're at 3,000. So let's see what they say. Along the way, it seems that many of those who worked on the exoneration innocent organizations, defense attorneys, prosecutors, judges, began to focus attention on innocent murder defendants who remain in prison and have been there the longest. So basically, they're saying is that they've been there so long and they already know they were innocent. All right, so they got their use out of these guys. And some of them truly had some conscientious disdain towards that. So I guess it's a multiplicity of things. But if you're unjustly incarcerated or charged for something that you did not do, it behooves you to get that person out, because that's egregious malfeasance in legal standards that your country has if you have people unjustly incarcerated. Now, if they're justifiably incarcerated for a crime they committed and did do, all right, maybe the sentence may be heinous and extreme, but they still shouldn't. You should have a uniformity in prosecution across the board. But that's not how it works here. This process would have occurred in different times in different offices, courts, and counties. Now, remember, counties connects to British law, the Magna Carta, ICJ. They separate different boundaries and areas into counties. In French territorial holdings, they have parishes. So like in Louisiana, you have like parishes where Lafayette, parishes where Baton Rouge or Baton Rouge, parishes where different cities are in, Shreveport, things of that nature. So England shipped a lot of prisoners. We discussed this in White Trash, the book by Eisenberg, I want to say. So a lot of prisoners came over. So you had a lot of different aspects of women reform schools and camps that were actually labor camps. And some of them, we discussed this in another video, shouts out to G-Dub. And they had that all throughout Canada, which was formerly owned by the French. So, and you had children that were spirited away. Some were involved in petty crimes. And they're picked up from the streets, specifically Irish, Italians, and they had a boy problem. They would form gangs and they would form different organizations that would rob and steal little petty things, and you know, they would have to deal with that. So it is what it is. That's where you get the guaranteed jobs for the police with the Irish, and the guaranteed jobs here in America for the Italians in the fire department. It is what it is. But whenever it happens, in most large American counties, the great majority of innocent murders of defendants who are identified will be black prisoners who have been inured for 10, 20, 30 years or longer. As they're exonerated, the proportion of black murder exonerees will rise, as will the average time of conviction of exoneration. How could it be otherwise? Innocent black defenders are not only more likely to be convicted of murder than innocent white defenders, they also receive harsher sentences, of course, and were less likely to be exonerated in years after conviction. Many of the innocent black murder defendants who spent decades in prison were exonerated by conviction integrity units. Remember, we discussed that yesterday. These are divisions of prosecutorial offices whose mission is to prevent, identify, and correct false convictions. The first CIU was founded in 2002 and did little. As often, I mean, you have numerous sub offices in the federal government, like Social Security actually has SSA, Social Security Administration, and they also have SSI, Social Security Insurance, and they have a fraud department that protects citizens, specifically men that are soldiers, from being falsely charged with children that they didn't have overseas. Okay, because a lot of women try to get these men's Social Security benefits and things of that nature by falsely claiming this kid is his. There were 2 CIUs in the country in 2007. They had been involved in 3 exonerations, and that just means that they were probably understaffed, and they really didn't take them overturning these prosecutions seriously. So, and they probably were underfunded also. So they probably only had a few people working for them. It is what it is. By the end of 2012, there were 9 CIUs across the country. In 2015, there were 24. In 2018, there's 44. And at the end of 2021, there was 93. The number of CIU exonerations has followed a similar pattern. From 2008 to 2013, there were 42 CIU exonerations, on average 7 a year. In 2014, there were 51 CIU exonerations. From 15 to 21, there were 441 CIU exonerations, an average of 63 a year. 37% of all exonerations in that period, 441 to 1,200. Since the beginning of 14, the CIU exoneration became common. CIUs have been involved in about a third of all murder exonerations, 170 to 538. 63% of all murder exonerees in this period are black. So that's 337 to 538. So that's 52%. Compared to 52%, no, that's 63%. Compared to 52% of 8 years from 2006 to 13. In line with the upward trend we see in Figure 5, but only 52% of non-CIU, that's 54%, since 2014 had black defendants, compared to 81% of CIU murder exonerations. 81%. So out of 170, 138 were black men that were exonerated. In other words, almost all of the increase in the proportion of black murder exonerees in the last 8 years is due to extraordinary concentration of black exonerees in CIU murder investigations and exonerations. The CIU murder exonerees in this period spent more than 21 years on average, compared to 17 for non-CIU murder exonerees. Have CIUs been addressing the backlog of innocent black murder defendants from decades past? Some clearly have. For example, maybe we talk about the Curtis Act, but that's another video. In 1988, Curtis Crossland, 23-year-old black guy, was convicted, so-called black, was convicted of murder in Philly for shooting a grocery store owner during a robbery. He was sentenced to life in prison without the possibility of parole. Crossland's conviction was based primarily on evidence that a witness who refused to testify at trial had testified at preliminary hearings that he heard. He didn't see. All right. Crossland admit that he shot the store owner. That conviction was reversed on appeal, but Crossland was convicted in 91 based on similar evidence, except that the second trial, the main witness did testify and explicitly recanted his earlier testimony. Over the next 29 years, Crossland and various attorneys working with him petitioned the state and federal courts many times to reopen his case. Along the way, they obtained statements from 3 witnesses who had not testified at trial. One was a store, and the other were at the windows across the street, who did not see Crossland, but identified other men who were at the scene with guns. All those petitions were rejected. In 2018, Larry Kransner took office as district attorney of Philly. In his election campaign, he promised to invigorate the county's conviction integrity unit, which until then had participated in 3 exonerations over a period of 4 years. In 2020, much more active Philly CIU agreed to review the Crossland case. They found a trove of previous concealed evidence, including documents that show the main witness against Crossland lied about that case and other matters on many occasions, and that a man who had been seen at the robbery by the witness who found at Crossland's post-conviction attorneys had also been identified to police to be the shooter, repeatedly in initial investigation in 98 and 88. In May 21, in a proceeding in federal court, the Philly District Attorney Conviction Integrity Unit agreed the Crossland conviction should be vacated because of the trial prosecutors violated Crossland's right to due process by not disclosing evidence. In June 21, charges were dismissed and Crossland was released after 33 years in prison. Curtis Crossland is the 22nd of 25 CIU murder investigations in Philly since 14. 92% of whom were black. That number is highly unusual. Most CIUs have no exonerations at all so far, including at least 9 units that opened 5 years ago or longer. Many others have been involved in 1 or 2 exonerations. And 138 black CIU murder exonerees since 14 are spread across 26. I don't want CIUs to spread across. Name them. But not evenly. Almost 4/5, including a third of all black murder exonerees in the United States in this period, come from CIUs in 8 counties. I bet they're all in like East Coast and some in Midwest. So let's see what they're saying. Oh, here we go. Midwestern cities and East Coast cities. Philly, 23. BK, Brooklyn, 19. Detroit, 19. And that's actually rising up to 21 because there's actually a CIU unit here and there's a couple cases that are being tried right now. So that's actually going to be 21 in a month. So Chicago, 17. I heard from some Chicago exoneration groups that's actually growing up to 19. So by the end of the year. So, and they have some more that people being released that were falsely incarcerated. So that number is going to change. You remember this report was done in June. So that's actually increasing. So let's just say 19 for when it was done. 21 right now for Detroit. So Detroit is actually right behind Brooklyn. Right behind Philly, excuse me. Philly has 23. Brooklyn has 19. Detroit has 21, not 19. Chicago has 17. It's actually going up to 19. Baltimore had 13. Boston had 7. We all know how Boston is. Queens, aka Left Rack, aka Queensbridge, whatever, 6. The Bronx, the BX has 4. There's no reason to think that this trend will slow down in those cities as more CIUs become active and the pace may accelerate. In some, we know how many exonerated murder defendants are black, 55% and rising. By the end of this year, it's going to be 57. And by next year, it should be about 60. So that means that 6 of every 10. So 55 is what they have right now, 6 of every 10. But we don't know the percentage of black people among all falsely convicted murder defendants. We also know that black murder exonerees spend longer in prison before exonerated than whites, which means that the rate of exoneration is rising. and has been since 89. Innocent black men, that's what they should say, may be underrepresented among those who have been exonerated. Since the beginning of 14, the number of murder exonerations who spent 20, 30, or 40 years in prison has grown, and the proportion of murder exonerees who are black has increased substantially. A handful of big city CIUs are responsible for most of that increase. Without them, 50% of murder exonerees since beginning of 2014 would have been black. With them, it's 64%. Wow. Now, what actually strikes me is, what about the small cities? What about those cities like Nashville, Louisville? What about those cities such as St. Louis, such as Kansas City, Missouri? What about those smaller cities like, I would say, Huntington? You would say cities like Montgomery or Beham in Alabama. What about those cities? Because I know there's a lot of false convictions in those cities. Biloxi, Mississippi. Okay. Lafayette, Louisiana. D, intentional and structural discrimination. In some cases, it is easy to spot racism in investigations or the prosecutions that led to the false murder convictions we study. In 80, Texas Ranger investigations, the rape murder of high school student described that was coming to the two custodians found the body. Clarence Brandley? Is it Brand? Like a Brandley? And white colleagues. All right. Let's check. We'll check the comments in a second. He said, one of you is going to have to hang for this, and turn to Brandley acts, since you're the nigger, you're elected. Brandley was sentenced to death in 81 and exonerated in 90. In Monroeville, so I know there's a Monroe County. Is that in Monroe? Is that where Monroeville is? Okay. No, there's a Moreno County, excuse me. Maybe that's there. Alabama. I don't know. I have to check. Police frame Walter McMillan. Yeah, McMillan, for the murder of clerk of a dry cleaners. McMillan, a 46-year-old black man, had numerous alibi witnesses, all black. He was at a fish fry at the time of the killing, but he also had a white girlfriend, which was reason enough for the police to target him. McMillan was sentenced to death in 88 and exonerated in 93. More often discriminated and is less overt in 14, Glen Ford. There's actually a dealership called Glen Ford, but was exonerated after 30 years of death row in Louisiana. He was released because of, over the decades after the conviction, his lawyers discovered several facts that undermine the state's case. Trial testimony by the state's expert witness. The expert witness had false or misleading evidence, and he did so to mislead police officers who lied to the jury about what Ford said to them. Hidden police records include tips from informants that implicated two other suspects, but not Ford. And one of those two suspects admitted that he was the actual killer. Golly. It was probably because he was sentenced for a series of murders, and they say, look, you're already going down for murder. Just talk about all the other murders that you've actually committed, and you get a lighter sentence, blah, blah, blah. He's yeah, all right, give me a burger. And I'll admit to all the other stuff. I'm already going for life. So he wouldn't get the death sentence often. In 2015, A.M. Marty Stroud III, a former trial prosecutor who put Ford on death row in 84. All this stuff is happening in 84. Published a remarkable apology. Glen Ford was an innocent man. He was released from the hellhole he had endured. You know what? I think that the lawyer should be disbarred, whether they're prosecutor, defendant. If so-called black men are falsely incarcerated for crimes, they should disbar them. They should lose their license, and that would stop a lot of false incarceration. Same with the judges. That would stop a lot of false, and same with the police officers should be licensed. just like a doctor's license, a lawyer's license. And when they have false incarcerations and they do mischievous and malevolent things, they should just lose a license. Simple. Stroud takes painful personal responsibilities for the tragedy, but not because of the deliberate misconduct. He was inattentive. My fault was that I was too passive. What? I did not consider the rumors about the involvement of parties other than Mr. Ford to be. No, he was concerned about his percentage. He had I been more inquisitive, perhaps the evidence would have come to light years ago. No, he was trying to keep his percentages up so he can get his bonuses and it can rise up to the junior partnership of different firms and things. And then Stroud described how he played by rules that gave him an unfair advantage over an innocent man. I did not question the unfairness of Mr. Ford having appointed counsels who have never tried a criminal jury case, much less a capital one. Even more troubling, the jury was all white. Mr. Ford was African American, so-called black. Potential African American jurors were struck. So basically, when you actually get jurors, you have to select jurors from a pool of people that best represents the defendant. Now, I get it. Some counties and areas have a majority of white people, and they're going to actually have a heavy prosecutorial sentencing on so-called black people. So, I mean, he should have had, his lawyer should have said, look, we need to get a different venue in an area where we get a fair trial. But unfortunately, they did not do that. About potential discrimination because of the time, a claim of racial discrimination in the selection of jurors could not be successful. Stroud, stop it. He knew that they were going to sentence him. That's why he had it in that specific venue. Stroud is unsparingly self-critical, but does not describe himself as a racist. Yeah, okay. And I'm not a man. I'm not a man. Okay. I'm not a man at all. If he's not racist, I'm not a man. In 84, I was 33 years old. Here we go. I was arrogant, judgmental, narcissistic, and full of myself. You're still. I was not as interested in justice. You're still not. I was in winning. I remember I told you guys that large want to get their percentages. I'm tired of hearing what he has to say. Some police and prosecutors have habitually, as Dave Chappelle would say, habitual line stepper. Shouts out to Charlie Murphy, rest in peace. Assume that any black murder suspects they deal with is a killer. That's false. Of course, it is a form of racial profiling. If they are white, they may mistrust claims of innocence by black defendants and alibi evidence from black witnesses because black people are unfamiliar to them and seem less trustworthy than those who are more similar to themselves. All of us, including judges and jurors, as well as lawyers and police, are subject to unconscious racial biases. Okay. Would Glenn Ford have been convicted and sentenced to death if he had not been a black man? See, finally they're starting with the so-called black man thing. They're starting to say black men because the majority of people exonerated that are black are men charged with killing white victims. ? There are no way to know. Hundreds of white defendants have also been falsely convicted of murder. Yeah, it's true. And most of their cases including serious official misconduct, but we know that innocent black men that are murder defendants as a group are at a disadvantage because of their race. And that sometimes it costs them their freedom and most of all, their remaining years. The net effect, part 3. We don't know the number of false criminal convictions for murder or any other crime. Most by far remain hidden. False convictions far outnumber exonerations, and we have little information to estimate the hidden figure, except in one context: death sentences. Death sentences have a far higher rate of exonerations than other criminal convictions, and we have far more detailed data on them than any other category of criminal sentencing. A study published in the Proceeding of National Academy of Sciences made use of the unique characteristics to calculate a conservative estimate of the proportion of false convictions among death sentences in the United States, 4.1%. As a study, it's careful to point out that this estimate is for death sentences only. It cannot be applied to all crimes or even all murders. Still, it is a starting point. It suggests that the rate of miscarriages of justice for murder is somewhere in the general guilty verdict or vicinity of the rate of capital murders. Assume for a moment that the proportion of innocent defendants among all murder convictions is half the rate for death sentences, at 2%. That would mean that there would be about 3,300 innocent defendants among an estimated 165,000 inmates who are in American prisons for murder convictions, plus thousands more among the comparable number of defendants who were convicted of murder in the past 40 years, but are not now in prison because they were released and have died. So they got released or they died in prison. In short, it is likely that there are several thousand defendants who have been falsely convicted of murder in the period covering by the registry, and judging from the exonerations we have seen, more than half of them were black. I think that number, this is my personal belief, is close to 75%. But at the end of the day, let's go check, before we get into this, check the comments. Okay, back at it. So, we're looking at sexual assaults. That's just rape. Nearly 6% of all rape exonerations involve black people who were defendants in less than a quarter of all rape convictions. The majority of rape exonerees were misidentified by victims who had been raped by strangers. 2/3 of those misidentified rape defendants were black men, most of whom were misidentified by white victims. Cross-racial eyewitness identification is a notorious risky process. It appears to be the leading cause of rape convictions of innocent black men in the United States. But it's not the only factor. Some of the misidentification were obtained by deliberately tainted identification procedures. The black men were also overrepresented in the minority of rape exonerations without misidentification. In addition, black rape exonerees receive longer sentences than whites and spend several more years in prison before release. The country has a horrific history of racism in addressing accusations of interracial rape against black men. The persistence of racism is easy to spot in some rape exonerations. In others, no doubt, it's hidden beneath the surface. Most rape exonerations are based on post-convictions DNA evidence that proves exonerees were not rapists. Since exonerations became increasingly uncommon as DNA testing became widely available to determine identity of rapists before trial, there have been no DNA rape exonerations for convictions after 2007. Race and false convictions for rape. 59% of sexual assault rape exonerees are black men, for most part, 4.5 times the proportion in the population. 33% are white. That suggests that innocent black people are almost 8 times more likely than white people to be falsely convicted of rape. Unlike murder, these numbers are way out of line with racial compositions of sexual assault convictions. As of the end of 21% of those serving time in jail and state prisons for sexual assault rape were black, 39% were white, and 25% Hispanic. Eyewitness misidentification. The leading cause of false sexual assault convictions is eyewitness misidentification. 98% of sexual assault exoneration have female victims. Strangers commit only about a quarter of rapes in the United States, but they account for 69% of the false rape convictions as a result in exoneration. So out of 350, 243 were from strangers. Okay, usually it's from people they know. So With let's say you have a white defendant, he might rape his daughter or stepdaughter, something like that, right? It happens. It does happen. And it's nothing to mock or make fun of, but usually that's from someone they know. And oftentimes they don't actually report some of those things. So yeah. And then you have rape that occurs in juvenile detention centers amongst young boys. That's something that's actually not discussed much, but it does occur. In 75% of sexual assault exonerations, the identity of the man who committed the rape was central issue of the trial. 87% of these cases were rapes by strangers, so 228 by 263, and 89% include mistaken eyewitness identification, 233 out of 263. In the remaining 25% of sexual assault exonerations, the assault never happened. So out of 350, 87 were black men. Instead, the supposed victim lied about consensual sexual encounter or fabricated an attack from scratch. Remember Brian Banks? Shouts out to him. I actually have that DVD on Blu-ray. Anybody that wants it, you guys hit me up, say you want it in the comments, and I will give you an email and I will mail it to you. It's Blu-ray, so if you have a Blu-ray player, I'll send it to you. Okay, just I'll hit you up with an email, say you want it, and give me a place, a P.O. box, wherever to send it to. Shame what happened to him. And the complainant knew the innocent defendant, so 72 of 87. There are eyewitness misidentification. It's 67% of all sexual assault. Why do I keep on using that word? Just say rape. I don't want to say that long word. Including 84% of the cases in which defendants were strangers to the victims. And 44% of all rapes that are exonerated, the eyewitness misidentifications, black men were convicted of raping white women. That's 44. So that means 66% were from black women, because mostly those are the women in that area. So there you go. A racial combination that appears in less than 11% of sexual assaults in the United States. So that means you are less than 11% of sexual assaults, so-called black men. According to surveys of crime victims, about 7% of white sexual assault victims were attacked by white men. It's proximity. Crimes are based on proximity. And only 13% by black men. But 52% of sexual assault exonerees with white female victims were black. Wow. And 43% of white, which suggests that black defendants were convicted of raping white women, are more than 6 times more likely to be innocent than white men convicted of raping women of their own race. So, if you're so-called black men are convicted of having sexual assault or rape on white women, it's a high probability it actually didn't happen. They say by 52%. And that's just with what's been tried and exonerated. But it's probably about 6 or 7, 70%. But this is the numbers we have, so we'll stick with 52%. There are many possible explanations for this disturbing pattern, but the simplest is probably the most powerful. The perils of cross-racial identification. One of the oldest and most consistent findings in systematic studies of eyewitness identification is that white Americans are much more likely to mistake one black person for another than to mistake identity members of their own race. The problem of cross-racial identification and rape prosecutions is America is asymmetrical. Okay, so asymmetrical, you have asymmetrical warfare, you have asymmetrical body types. Women they tend to be asymmetrical, which means they actually have a greater propensity of actually hurting their lower legs because their body, too much weight is centered around their hips and thighs, and they actually land awkwardly, and all that weight goes down in a weird, plus they have weird jumps and things when they play different sports, so they often land and put too much weight on their knees, which causes MCLs and ACL tears. So the asymmetrical bodies, whatever, It poses a greater risk of misidentification of Black sexual assault defendants. For men are usually symmetrical for defendants than for white defendants for two reasons. First, a lower proportion of sexual assault by white perpetrators are cross-racial. Most sexual assault victims are friends, family members, remember I told you that, or acquaintances of the attacker, who are likely to be of the same race. And if the victim is a stranger, she is likely to be white regardless of the race of the attacker, simply because whites are a great majority of the population. Second, in the experimental studies, white subjects show stronger own race bias than Black subjects. They tend to be worse at identifying members of their other races. This is not surprising, as members of the majority group, many white Americans have less contact with Black people, but almost all Black people have regular dealings with white people. Misconduct, discrimination, tainted identifications. Marvin Anderson was suspected of rape in Virginia because the real rapist told his victims that he had a white girl, and Anderson was the only Black man known to local police who lived with the white woman. Okay. Anderson had no criminal record, so an officer showed his color, employment identification photo to the victim, together with a half dozen Black and white mugshots of other men, and asked her to pick the perpetrator. Naturally, she chose Anderson, who spent 15 years in prison before he was exonerated by DNA. Anderson's false conviction was a product of tainted identification, a dangerous form of misconduct in which police directly, as in the case, indirectly tell a witness to pick a formal identification procedure. Tainted identifications occurred in 10% of investigations of defendants who were convicted of rape and later exonerations. So that's 35 out of 350. That's about the same rate of what we saw for murder exonerations, 112 to 1,167, but the process was quite different. Murder cases are 40% of tainted identifications, threats that are used to induce the witness to identify defendants, usually threats of arrest or prosecution. Look, if you don't say this, we're going to arrest you for the crime and charge you for this also. Predictably, that happened in nearly half of tainted murder identification of Black exonerees. Okay. But only 11% of the few tainted identification for white murder defendants, 2 of 18. In sexual exonerations, rape, the victims always survive the crimes by definition, because of if a victim is killed, the case becomes a murder. Unlike murder prosecutions, a critical eyewitness in a sexual assault case is almost always a victim. Perhaps for that reason, none of the tainted identification sexual rape include threats by police. Instead, Marvin Anderson's case, they draw attention to a person they suspect without saying so. For example, Thomas Doswell was identified by a rape victim in Pittsburgh, who was shown photographs of 8 men, one of which was Thomas, and had the letter R for rapist written on it. He was exonerated 19 years later for DNA. In other cases, the authorities were more straightforward. After a rape victim picked a man standing next to Anthony Broadwater in a lineup in Syracuse, New York in 1981, the prosecutor told her, "Of course, you chose the wrong one." He and his attorney worked to make sure you never have a chance. He had a friend come down and stand next to him. "We want to send a car to the prison and get him here." That wouldn't go ahead until he showed. They totally worked the number on you. He uses that friend, or that friend uses him in every lineup they do. They're dead ringers. Every part of the prosecutor's statement were false. After the victim identified him as Trout Broadwater, spent 16 and a half years in prison and 21 years as a registered sex offender before he was exonerated in 2021. In Jerry Lee Evans' case, Dallas police simply told the victims when the picture was shown, he spent 22 years in prison before he was exonerated after release. In 3/4 of murder exonerations with tainted identification, one or more eyewitness lied, deliberately misidentified the exoneree, 84 out of 112. In cases which they were threatened, 44 out of 84. That's over half. In the absence of threat, only 2 rape victims had tainted identifications, include deliberate misidentification of the defendant. Rape exonerations without eyewitness misidentification. In a third of rape exonerations, there were no mistaken eyewitness identifications. Nonetheless, 45% of the exonerees in those cases were black. Less than the rate of rape exonerations, the misidentification, but more than twice the proportion of black people among those in prison for rape, and about 3 times their population. In 3/4 of rape exoneration without misidentification, no rape was committed. 87 out of 117. Most often, the complaints lied and accused the defendants of rape after consensual sex. There you go. In a few, they said they were raped and avoided many consensual sex with someone else. In a couple of other cases, the complainants were delusional. So the women might have been in a relationship. They didn't want their boyfriend to know. They might have been having sex with a person that was a different race. They didn't want their family members to know. Whatever it may be, they're also delusional. Okay. So at the end of the day, a lot of times you have a lot of consensual sex that has occurred and people are falsely accused for it. Shouts out to Patrice O'Neal. He had consensual sex with a woman when he was in the 11th grade, and she falsely charged him for something that he did not do. In 1983, Stanley Rice, a black man, was convicted of participating in a vicious gang rape of a white woman in Chicago and sentenced to life in prison. The victim did not identify Rice, but he had confessed, and 2 witnesses testified that they saw him participate in a rape. Probably different gang members, more than likely, and they probably had sentences in something else and they can get lesser charges, blah, blah, blah. Rice was exonerated in 2013. It was established that he had been tortured by confessing to 2 officers in Chicago police, and they specialized in obtaining confessions by torture, mostly from black murder suspects. 2 years earlier, the commander, Lieutenant John Burge, was sent to federal prison for committing perjury and testimony about the unit. By then, one of the 2 supposed eyewitnesses, also a black man, had recanted and stated under oath that he too had been tortured. There you go. And forced to testify against Rice. See, they probably had murders hanging on them. And say, look, you got a murder charge. And, this is just some bullshit, Just say he did it and we get this under wraps. You get it convicted. So they're like, oh, man, I got to beat this murder rep. And it probably came out. Shouts out to them actually admitting that they actually lied. And I respect that. Racism and discrimination. Racism and rape prosecution have also become a self-fulfilling prophecy. And the excuse for misconduct in some cases, the critical players are defense attorneys, judges, or jurors, rather than prosecutors or police officers. Michael Phillips, in 1990, a black man in Dallas, pled guilty to rape 16-year-old white girl who misidentified him. Phillips later said that his lawyers never investigated his unanswerable claim that he was physically incapable of committing the crime. Instead, she persuaded him that he would get life in prison if he went to trial because no jury would believe black man over white girl. Phillips spent 12 years in prison, unusually long term for rape by the defendant, with no prior records for violence and sexual misconduct. He was exonerated in 2014 when a rape kit was finally tested for DNA. In some cases, the presence of racism is unmistakable. And where is this at? Illinois. This is DuPage County, Illinois. So that means DuPage County. Marcus Lyons had recently been released from prison after completing a sentence for rape. He tried to call attention to his case by putting on his Navy uniform, going to the steps of the DuPage County, Illinois courthouse, and nailing his foot to a cross made of railroad ties. One of the officers who stopped him said, "Come on, nigger, your 15 minutes of fame is over." Lyons was exonerated in 2007. A DNA test for semen found on underpants worn by the victim. He might have been cleared in 1988 if blood type testing had been done on those underpants by the police, who knew the pants had never been tested. That the lawyers believe that there had been no semen found. In other cases, let's see, where is this happening at? Happened? 2014, 2015, 2016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, 2024, 2025, 2026, 2027, 2028, 2029, 2030, 2031, 2032, 2033, 2034, 2035, 2036, 2037, 2038, 2039, 2040, 2041, 2042, 2043, 2044, 2045, 2046, 2047, 2048, 2049, 2050, 2051, 2052, 2053, 2054, 2055, 2056, 2057, 2058, 2059, 2060, 2061, 2062, 2063, 2064, 2065, 2066, 2067, 2068, 2069, 2070, 2071, 2072, 2073, 2074, 2075, 2076, 2077, 2078, 2079, 2080, 2081, 2082, 2083, 2084, 2085, 2086, 2087, 2088, 2089, 2090, 2091, 2092, 2093, 2094, 2095, 2096, 2097, 2098, 2099, 2000, 2001, 2002, 2003, 2004, 2005, 2006, 2007, 20 Okay, in other cases, in 84, Ulysses Charles, a black immigrant, he was an immigrant from Trinidad and Tobago who spoke with a strong Caribbean accent, was convicted of raping 3 white women in Boston. Trinidad. Yeah, man. So he was in Trinidad, coming straight from Trinidad. He probably was working service field, more than likely. All 3 victims misidentified Charles as the rapist, even though they told police that rapist had an American accent. He had failed to mention Charles' dreadlocks, dready man, and gold front teeth. Before trial, tests on crime scene evidence found similar. They found semen from the rapist and showed that the attacker had blood type O. Charles and the police knew that he had a blood type B. That is odd. Usually you have an O type. The evidence was concealed, and let's see what his last name is. Charles, British or Irish ancestry, more than likely. Falsely, the rapist had not ejaculated. Charles had been exonerated in 2001 after 20 years in prison with DNA testing. Wow. One of the problems that plague American criminal justice, few, if any, are incendiary as the relationship between rape and race. From the Reconstruction through the first half of the 20th century, claims that black men raped white women triggered countless lynchings, riots, and sometimes massacres of black people. Those horrors have stopped, but the fears and biases that fed them have not disappeared. It would show no surprise that racial bias and outright racism also play a role in wrongful convictions for sexual assault, sentencing, and time in prison before exonerations. Interesting. Let's look at charges over time. Rape exonerations are decreasing. All across the time span of the registry, murder exonerations increase in a factor of 5, from 14 a year in 89 to 92 to almost 72 a year in 2018 and 21. As we saw in Figure 1, rape exonerations also rose in the first dozen of years of the registry, from a few in 89-90 to a peak 23 and 02, but then fell back on average about 13 a year through 17, before dropping to less than 10 in the last few years. And let's look at the chart. The comparison is equally telling when we examine exonerations by year of the convictions of innocent defendants instead of the year in which the exoneration occurred. Okay. They dropped rapidly for a decade, averaging about 4 a year for convictions from 01 to 2010, and about 2 a year since. So you see the peak right in 91 because they start using DNA evidence, and then you see a drop off in 2000 now. The cause of this pattern has no mystery. It's not a mystery. 2/3 of rape exonerations are for convictions from 73 to 94, 237 to 350. 80% of them were based on post-conviction DNA testing. After that, DNA rape exonerations declined for convictions through 07 and then disappeared entirely. Non-DNA rape exonerations, by contrast, have occurred as a reasonably steady low rate for convictions since 82, averaging about 3 a year. DNA testing is extremely effective in identifying a person who has left testable biological evidence at a particular location. Because rapists usually leave semen or other biological material in or near the bodies of the victims, DNA evidence can be uniquely effective for determining whether the defendant who was convicted of rape is in fact a rapist. The main reason for the surge of rape exonerations after post-convictions, DNA testing became available in the United States in 89. 225 exonerations to the date, 85% of which include eyewitness misidentification. DNA testing is no help in determining guilt or innocence in a rape case when the identity of the person who had sex with the complainant is not an issue, usually because only dispute in whether sex was consensual. Okay, judging from exoneration, it appears that for 14 years, all or nearly all innocent rape suspects in the United States who might benefit from DNA testing were never convicted because the DNA evidence cleared them before trial. Unfortunately, a minority of misidentified rape suspects do not benefit from DNA testing because, one reason or another, there is no biological material to test. There's been 136 exonerations of misidentified rape defendants who were convicted from 1980 to 89, about 14 years. Only 12 who were convicted in 10 years from 2000 through 09, and just 2 in 12 years since. It seems that now the pretrial DNA testing is well established in the United States. The number of false rape convictions based on misidentification has plummeted. More than 7% of innocent rape defendants who were mislabeled and convicted in the 80s were black men. Shoo! 7% of innocent rape defendants who were misidentified and convicted in the 1980s were black men. I'll repeat that. More than 7% of innocent rape defendants who were convicted and misidentified in the 80s were black men. 7% whom were convicted of raping white women. On the handful who were misidentified in the 21 years since 2000, only a third were black. By preventing most false convictions or misidentification, rape defendants has eliminated the bulk of disproportionate, often discriminatory, and sometimes racist convictions of innocent black men who were accused of raping white women. Drug crimes. And we're going to finish this whole section off. Let's see how far it is. Okay. Drug crimes. Let me take a little bit of a break, and I'll be back in a second. Check these comments. Okay. Back at it. Drug crimes. 69%, not the rapper, 69% of drug crime exonerees are black and 16% are white. I wonder why that is. That means that innocent black people, black men, are 19 times more likely to be convicted of drug crimes than innocent white people. By now, this finding may seem, depressingly familiar, but it is actually much worse than anything we've seen and probably underestimates or understates the actual disparity. White and so-called black men that are American use illegal drugs at similar rates. Actually, there's more white people that use drugs because there's more of them. And the greatest drug abuser is actually a 40-year-old white woman and up, because she has a great propensity to get access to pharmacology drugs and illegal drugs. And she has a lot of disposable income. Often goes through divorces around that period, around the 30s on up. So she is much more likely to actually use drugs. That's just saying. Okay, since she's a majority of U.S. citizens. Just saying. At several times the rate of white people, that's because essentially none of the huge number of drug crimes in the United States are reported to police, so they get to choose who to investigate, search, and arrest for drug charges and crimes. They usually choose black people. That's racial profiling, the process by which the war on drugs is focused on minorities, especially black men. Most innocent victims of racial profiling are stopped, searched, harassed, humiliated, but not arrested. That is true. When you're racial I've been racial profiled. You're never arrested, and you're actually not even given tickets. You're usually just pulled over. They search through your car at gunpoint. Usually their gun is out their holster. But yes, they never give you tickets, ever. Sometimes they're looking for money. When I was living in the hood, and a lot of the drug dealers carry a lot of money on them, they just seize it. Where'd you get this money from? And, most of the drug dealers, they know how to get the money. But a lot of the times, the cops, they're on pay by other drug dealers and stuff like that. And they just want to get his money. And, some of the drug dealers just pay him off. A lot of corruption. But some are arrested and convicted in error, usually because of unreliable field testing for drugs. That's another thing. I see movies. We got dudes that would dip their finger in cocaine. No drug dealers in the hood actually dip their finger and taste cocaine. They don't do that shit. Or heroin. They don't do that. Oh no. They have a kit and they use eye drops and things of that nature to test the purity. No. Stop doing that in your TV shows. That is ridiculous. Yeah, this is good. Rubbing it all through their mouth and stuff. What is this? Toxic. You got it. Oh, that's just stupid. Who's be sticking it? Yeah, that's good. That's good coke. What? Who does that? That's such Hollywood stuff. The victims are black people who were never stopped, searched, and subject to that risk because of their race. In addition, we know that 17 groups of defendants who served wrongful convictions of drug crimes by systematic police misconduct, including many who were framed by police officers who planted drugs on them. Almost all are black people. They say black men or other people of color, Puerto Ricans, some Mexicans. The registry includes 250 exonerations of defendants who were convicted of such fabricated drug crimes, particularly in 3 group exonerations. 3% were white, 9% were Hispanic, 87% are black. Jeez. The structure of drug crime enforcement. Arrests. Hold on a second. 87% are black. Wow. So Hispanics, you're only 9% of the false incarcerations of drug crimes. 87% are so-called black men. Dang, that's crazy. There's no Asian. So if you're an Asian drug dealer, you're safe. They ain't pulling you over. You can drive around with keys of Molly, keys of stuff in your trunk. They ain't gonna pull you over at all. White guys, you're not gonna get falsely incarcerated from drugs. You'll be fine. Arrest is the intake valve of criminal justice. Most criminal investigations are initiated when civilians report a crime to police. Okay, so occasionally police witness a crime themselves. Either way, the first task to identify and arrest a criminal, unless an officer saw the crime and sees or recognizes the criminal, that may require questions, eyewitness, conducting investigation procedures, collecting physical evidence, and forensic evidence. Murder and rape causes the cases follow this pattern. Police initiate investigation of those crimes that are reported, or rarely the officers observe, and arrest suspects if they're able. Drug crimes are totally different. Nobody has plausible estimate of the number of drug crimes committed in the United States. But they happen millions of times each day. For all the practical purposes, none of these drug crimes are reported by the police. And despite more than 100,000 arrests a year, the risk of arrest for drug crime is tiny. 1 in thousands, far less. How do police find these unreported drug crimes that do produce arrest? More than 85% of drug arrests are for possession of illegal drugs. Virtually all arrests are for the sale of, manufacture, or drugs. In most possessions, the police find drugs by searching suspects. That's Terry frisking, stopping, or their possessions or vehicles or homes. Almost all these searches are conducted without warrants. Yep. And often by threat of gunfire. So, we so-called black men, we're pulled over, and what happens usually? 4 police officers pull up behind them, because if they're going to do their bullshit, they're going to do it in a group. And then they'll take their gun out their holster and tap on your window. This happens. Hey, pull the car over, roll the window down, get out the car, XYZ. So when you're in college, they'll go into your trunk without a warrant. It's like, look, you can tell them you have a warrant. They'll be like, oh, I got a warrant right here. Show the gun in your face. I had a police do that. And that happened a couple of times to me. And they threw all my college books out. It was snowing too. Yeah, it was bad. Messed my books up. And I was late for a test. I remember this. This was calculus in college. Yeah, I was late for a test. And the guy was like, why are you so late? I was like, man, I was, pulled over. Let's see, where are we at? Almost all the searches are conducted without warrants and often without specific reasons. That's called a preset stop. To believe that legal drugs might be found. Since the crime is possession, once drugs are found on a suspect or in the control, there's usually nothing left to prove. In short, police search people for drugs and arrest them when they happen to find what they're looking for. But who they choose to search? Spoiler alert, usually black men or other persons of color. Race and drug crime prosecutions. The best systematic data of illicit drug use in the United States come from anonymous annual surveys by Federal Department of Health and Human Services. The most recent surveys include data on race. In 2018, it found that 11.7% of the population over 12 years of age had used illegal drugs in the previous year, and that white and black Americans did so at comparable rates, 12% and 13% respectively, and similar patterns for earlier years. Drug arrest convictions that means that there should be far more white people that should be arrested for possession of drugs, since 12% of 100 plus million is far more than 13.7% of 40 million. But just saying, drug arrest convictions are another matter. A study Human Rights Watch found that from 80 to 2007, a period that includes 3/4 of convictions that led to exonerations in the registry, black people were arrested for drug crimes at 2.8 to 5.5 times the rate of white people, depending on the year. Data from FBI shows similar patterns of years since convictions filed suits, as best we know. A study of the Census Project at 2009 found that 95 to 2005, black people constituted about 13% drug users and 30% of drug arrests, and 40% of these convictions of felony drug offenses. Over that 10-year period, the black drug users was about 2.5 to 3 times more likely to be convicted of drug felony than that of white drug users. 30% of those serving prison terms for drug offenses are black, more than twice their proportion of population, about 4 times the rate of whites. Most drug crime convictions, however, are misdemeanors. There are no systematic national data on misdemeanor drug convictions, but there is every reason to believe they exhibit the same sort of racial disparities we see in other parts of drug enforcement in America. Yeah, I remember one time I was pulled over going 5 under the speed limit, again, a preset stop. And the guy was driving behind me for so long because they start using SUVs at this point. I was like, man, what is this SUV following me for? So I slowed down even slower than 5 below. Where I was like, because I thought I was being followed. I got kind of nervous. Like, who was this guy in the SUV following behind me? And he got out of jurisdiction and he pulled me over. out of his jurisdiction. So his city didn't even get the ticket that he gave me. He couldn't give me a ticket for anything. I don't even know what he did. Gave me a ticket for, but yeah, same thing. Pull the gun out. Where's your warrant? You know, I ain't got time to argue with some racist white guy. Hopped up on steroids, probably drunk. Who knows? You know, all types of drugs. Those cops. You know, this was years ago. F him. Innocent drug crime defendants. And no, I didn't have any drugs, and I don't do drugs. But at the end of the day, yeah, that's the first thing he asked. She's like, "You have drugs in the car?" It's like, no, you more than likely have drugs in your car and your system. I didn't say that, but you guys know. Most of them dudes are high on something anyway. Most defendants who are convicted of drug crimes get light sentences by American standards. Among the minority who are convicted of felonies, fewer than 40% go to prison. And the average sentence for those who are incarcerated is 2.5 years, about a quarter as long as for defendants in prison for rape, and 8 as long as those in prison for murder. But the great majority of drug convictions are for misdemeanors, for which the worst possible sentences are months in jail rather than years in state prison. In practice, many, if not most, convicted misdemeanors of drug defendants get no time in custody. Excluding drug cases, very few defendants with such comparable light penalties are ever exonerated regardless of innocence. Most of all, the effort that goes into addressing wrongful convictions is devoted to defendants with extremely severe sentencing. As a result, the distribution of exonerations is heavily lopsided. At the top of the range, defendants who are sentenced to death are about 6 times more likely to be exonerated as those convicted for murder, but not sentenced to death, and 100 times more likely than defendants convicted of robbery. And shouts out to the Maya Moore and her husband, who was actually falsely convicted of robbery. So he's exonerated. And so down the line, excluding drug cases, nonviolent crimes make up more than 60% of felony convictions. But only 14% exonerations. There are, for example, about 3 times as many felony convictions for theft as for robbery, but 1/8 the number of exonerations. Okay. Misdemeanor convictions outnumber felonies by at least 4-1, but account for less than 2% of non-drug exonerations. Clearly, only a tiny fraction of innocent defendants who were convicted of misdemeanors are non-violent felonies or ever exonerated. Most innocent defendants with relatively light sentences probably never tried to clear their names. They serve their time and do what they can do to put the past behind them. If they do seek justice, they are unlikely to find help. For example, Center for Wrongful Convictions in Northwest University, School of Law, Northwestern. Oh, that's in Chicago. One of the organizations that founded the registry used to limit its intake cases to prisoners who had at least 10 years remaining in their sentences because it was overloaded with innocent cases in which stakes were high or higher. In addition, minor crimes generally are more difficult to reinvestigate than violent felonies because the initial investigations and the record keeping is usually more limited. So there's less to go on. Most exonerations are for convictions at trial, which generate and preserve much more information than guilty pleas. And trials are vanishing rare in drug cases. And 2000, for example, 4% of felony drug crimes convictions were obtained at trial. By contrast, 19% of rape convictions and 42% of murder convictions were obtained at trial. Drug crimes are the second largest crime category for exonerations after murder. They account for 17% of all exonerations, but include a majority of misdemeanor exonerations. Almost a third of exonerees in non-drug cases in registry were sentenced to death or life imprisonment. Only 8 of the 554 drug crime exonerees were subject to life in prison. Less than 2%, and the median sentence for the rest of it was a year in jail. Okay, so that's a felony. That's 366 days. Clusters of drug crime exonerations. H-Town, Houston, arrested 17-year-old Michael Jones. Who? Mike Jones, After they seized a powdery substance from him, it was this 09, and tested positive for presumptive field test for cocaine. 2 days later, Jones pled guilty to possession of a controlled substance. He would say, look, just plead with a lesser charge and blah, blah, blah. And was placed on probation for 3 years. In 2011, Houston Police Crime Laboratory tested the powder and found no controlled substances. 3 years after that, November 2015, charges were dismissed and Jones was exonerated. Basically, he may have got some BS and he may not have had anything on him. Okay, may have been talcum powder, who knows? So it's like, look, just you'll be out of here in a couple of days, blah, 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 blah. Let's just take this and we'll deal with this later. Okay, because I already know that he's going to get a guilty charge if he takes it to trial and they do all this testing, this and that. And you have a lot of malfeasance within that office and criminal investigation units, and it is what it is. Why were they supposed drugs seized from Mike Jones? Case tested 2 years after he pled guilty and was placed on probation. Normally, a case like this would have been entirely forgotten long before then. But Mike Jones' case did not proceed on his own steam. It was one of the cluster of 157 exonerations for wrongful drug convictions in Harris County, Texas, home of Houston, that all was a common cause. No single one of these cases would have been, they would not have had attracted the attention and efforts necessary for exoneration. But once the general pattern was discovered, exonerating each individual case became routine. As we'll see, the nature of the cluster also explains another curiosity about Jones' exoneration. Why did it take 3 years after lab tests had definitively cleared him? The Harris County case are one of 4 clusters that account for 72% of all drug crime exonerations on the registry. These clusters fall into 2 categories that reflect 2 common scenarios, which innocent defendants are falsely convicted of possession of illegal drugs. Error. Number 1, materials the defendant was convicted of possession were not in fact the illegal drugs they appeared to be. Misconduct, the drugs used to convict the defendant were planted by police or simply booked in as evidence by the officer who falsely said they had been taken from the defendant. So, for instance, you might have somebody that may have high blood pressure, and they might take a drug for high blood pressure. Let's go back to medical pharmacology books from college. So they might have had blood pressure, right? And they take specific drugs for high blood pressure. And they're like, look, I'm sick and tired of taking all these expensive medical pharmacology and polypharmaceutical. Polypharmacy means you're taking a multitude of different drugs that deal with other ailments, oftentimes misdiagnosed. So you're like, look, man, I ain't about to spend $300 to $500 on a bottle, even with healthcare. You must be crazy. Show me some natural things. So a person says, you know what? You can actually take kale, you chop it up. You can take this plant, not weed or sweetgrass as we call it, and it actually reduces inflammation. Not weed, I'm talking about other things. Natural. You can take, there's natural, you have physostigmines, right? Which are alkaloid, which are used in aspirin. Shouts out to Dr. Percy Julian, who pioneered those. And you find those naturally occurring in Mexico in specific plants and specific foods that you can actually just go and cook, or you can dry it out and you can mix it in and you can eat it, and it will reduce your high blood pressure. Simple. Looks just like a potato. All right. So you have this stuff and it's dried out. You have it in like little bags of stuff because you got to wait for it to dry. And people, oh, that looks like weed. It's not. And they'll test it and they'll think, oh, well, that's kale. And that's actually a specific plant that is rich. And he said, well, I have high blood pressure. Oh, okay. And the guy that's in the lab knows about this. He knows you can have natural supplements and natural plants and stuff, but they'll still book it in as evidence as drugs, as marijuana, but it's not. You can't even smoke kale. I don't know. Would you even smoke kale? I don't know why you do that. Error. Post-guilty plea drug testing exoneration in Harris County. Many drug defendants like Mike Jones pled guilty within days of arrest before the alleged drugs taken from them are tested in laboratory. That almost means that those supposed drugs are never tested except in Harris County, where the police laboratory often does those materials, even after guilty pleas, sometimes discovers that they contain no illegal drugs. Over the years, a handful of those negative tests led to exonerations, but most were unnoticed or ignored until 2004, when Harris County District Attorney Office launched a systematic program to track down the defendants who had pled guilty for possession of illegal drugs. Lab tests showed they were innocuous substances. That led to 157 drug crime exonerations, including several before 14. Misconduct, group exonerees. As we term group exoneration, has a specific meaning: the exoneration of a group of defendants who were convicted of crimes as a result of large-scale patterns of law enforcement, perjury, and corruption. Long term, we now have data for 33 such groups, including thousands of exoneration defendants who devoted a separate section of the registry website. Those include and add new ones regularly. In 17 of those group, substantial numbers of defendants were convicted of drug crimes that were fabricated by police officers, usually by planting drugs on innocent defendants. Oh, he did a crime, sprinkle some crack on him, like Dave Chappelle would say. You know, sprinkle crack on him. However, 288 exonerations from these groups include registry, which 259 were for drug crimes. More than 90% of drug crime exonerations in the registry, and 3 groups of the Rampart Group in Los Angeles grew 25 individual drug crime exonerations that occurred in 99 to 2000. The Tulia Group of Swisher County, shout out to Mike Jones, Texas, has another 35 from 2003, and the Sergeant Watts Group of Chicago has added 183 drug crime exonerations since 2006 and counting. Patterns over time. In sections of racial patterns in exoneration for murder and rape, we examine changes over time in numbers of exonerations by year of conviction. Look at figure 10. So you got Swisher County, that's what, 80, and that's that one right there in 2003. Harris, screen right there. So we see that they actually start testing and say, oh, there ain't no drugs in that at all. What's it? LA, Rampart, 99. Boom. Cook County. Cook sounds like Chicago. Yeah, Cook County. Shouts out to the Blues Brothers. Jeez, 2022. Woo. Yeah, a lot in 2022 and counting. Okay, so it says, as we see in figure 10, the overall drug crime exonerations over time. The blue line closely tracks the peaks and valleys of 4 clusters, including 3/4 of all such cases, 554. The Harris County cluster of post-guilty plea lab testing exonerations. Okay. So you got Rampart Group in LA, the Tulia Group in Swisher County, Texas, in 2003, and the Watch Group in Chicago from 2016 onward. Well, I know where I'm not going to Chicago. Oh, no, because they pulling dudes over for no reason in a Watts Group. Mistaken convictions discoverable after guilty pleas in Harris County, Texas. More than a quarter of drug crime exonerations we know about occurred in Harris County, Texas. No, I'm not going there. Almost all from 2012 to 18, 157 to 554. As we mentioned, the defendants in these cases pled guilty of drug possession. And that's a shame on their lawyers. Before there were supposed drugs they possessed were tested in crime labs and were exonerated weeks, months, or years later. After testing was done, no illegal drugs were found. The Harris County I'm avoiding Harris County, Texas. The Harris County exonerations are more typical of a run-of-the-mill American drug convictions than any other set in the registry. They all based on guilty pleas, mostly quick ones. More than half were entered within 4 days after arrest, compared to the median 5 months from arrest to conviction for other drug crime exonerations. And 40% of misdemeanors. That means that they were giving them misdemeanor beefs. Oh, you just cop a misdemeanor. You'll be out of jail in 2 weeks or a month. close to 90% of the misdemeanor drug exonerations and half of all the misdemeanor. See, what you have to do is look at ALEC, ALEC, and look at what prisons that were private that were actually popped up in this area so they can get free slave labor from some of these guys that get misdemeanors 2-3 month charges. You got to look. It's a system. Okay, 90% of misdemeanor drug exonerations and half of all misdemeanors exonerations in the registry, and the penalties were light by American standards. 20% Harris County drug exonerees got probation with no time in custody, have a sentence of 2 weeks in jail or less, and 5% were jailed for 1 year or longer. Among all the drug crime exonerations, 8 were sentenced to light imprisonment, and the median sentence for the rest was 2 years in prison. But why? Why do defendants in these ordinary seeming drug cases plead guilty even though they possess no drug controlled substances? Some may have had powders or pills that they thought contained illegal drugs, but did not, as far as we can tell. However, most pled guilty in order to get out of jail. Yep, their lawyers like, look. Sorry about that, guys. It seems as though the stream just dropped, but we're back at it. Let's get back to where we were. The only reason why, where was I at? The prosecutor made a for today, only take it or leave it offer for the defendant plead guilty and go home immediately, or in a few days or weeks if the defendant pled not guilty. However, they will remain in jail until trial, usually for months, sometimes for a year or longer, and the risk years in prison if convicted. It's hardly surprising that many innocent defendants took the deal. The only reason we know about these false guilty pleas in Harris County and Houston, police crime labs tested material seized in drug defendants even after they pled guilty. Few crime labs do that, which means that in many, if not most ordinary drug convictions, lab tests are never done, since 95% of drug possession convictions are based on guilty pleas that are often entered quickly. So a lot of labs across the country don't even do testing on the drugs. They say, oh, yeah, it looks like drugs. The Harris County drug exonerated, they don't even test it. Were exonerated by fortuity. This happens to be arrest in the only county in the country that conducts routine post-conviction drug tests. There is no reason to think the police are more likely to arrest innocent drug defendants in Harris County than in other counties, but if they do, they're far more likely to know about this. Okay, so post-plea drug deals. We learned that about 1,000 of additional false drug convictions across the country. The context may be unique, but racial composition of Harris County drug exonerations is familiar. 62% of exonerees are black in the county, and 20% of black residents, more than 6 times the rate of other racial groups. Most, if not all, of these innocent black defendants in Harris County pled guilty rather than go to jail or go to trial. It was their best option, given that they had arrests and charges and were held in jail. Why are so many innocent black men arrested for drug possession when there is no reason to believe black people are more likely than white people to use illegal drugs? Well, 79% of arrests in black Harris County drug crime exonerees were based on cheap, notoriously inaccurate presumptive field tests for drugs, which are often used on suspicious substances found in searches following traffic stops. Sometimes street stops are as well. Anybody who is subject to that sort of drug searches and risk of false arrest and possibly false conviction, the issue is who the police choose to search. In 2008, Department of Justice found that across the country, black men are about as likely to be stopped as white drivers. But after the stop, they're 3 times more likely to be searched. 12 years later, detailed government study of police stops and racial profiling in California found almost exactly the same pattern. In other words, black people they bear a heavy, disproportionate share of the burden of drug law enforcement by American police, from inconvenient, embarrassing, frightening, and sometimes destructive or violent searches or false criminal convictions for drug possession, which may number in thousands a year. Why do officers search black people for drugs? Black men at such a high rate. Several overlapping strands contribute to this practice. Some drug searches and arrests are a result of overt racial discrimination. In June 2016, federal judge found substantial evidence of racial selective drug law enforcement in San Francisco Police Department. In a program that results in indictment of 37 defendants for drug dealing, all black, the officers involved made derogatory comments about black males and ignored drug dealers of other races. 6 months later, all pending charges were dismissed. More often, discrimination is non-explicit. Black people are subject to more attention and surveillance from police than white people. One reason is that it is often offered that they are more likely to live in high crime areas, but that's not a complete explanation. In 2013, federal judge found New York City's notorious stop and frisk program, under which police made more than 4.4 million street stops from 2004 to 2012, 80% of them were black people or Hispanic, could not be justified on the basis because stops were most closely linked to racial composition of neighborhoods and race of those detained than for crime rates. Another reason that's given, usually for searches and after stops, black people are more likely than white subjects to have criminal records. That's true, but like the residential crime rates, it does not explain the racial pattern for searches. It is also particularly circular, especially for drug crimes. A major reason black people are more likely to have drug crime records is that police are more likely to stop, search, and arrest them and harass. Those records, however, obtained also mean that the bail is likely to be higher. Like drug defendants are more likely than whites to face the Hobson's choice of plea bargaining and plead guilty to stay in jail. Plead guilty or stay in jail. Black people, of course, are the prime targets of racial profiling. Selective suspects for investigation, detention, or arrest because of their race. The Stop and Frisk program in New York was racial profiling on citywide basis, city sidewalks. But the phrase racial profiling was first used in the late 1990s and was called driving while black. They described systematic police programs to troll for drugs on highways by searching cars of black and Hispanic drivers. It happens on highways, despite the fact that police are likely to find drugs when they search white suspects in the cars, if more not so. Our war on drugs requires police officers to search for drug crimes that no one reports to them. All right. They may also believe, usually correct, that black drivers are less likely to have connections to resources to complain effectively about rude, demeaning, destructive, and fruitless and often illegal searches. Most of the victims of drug searches are inconvenienced, often scared and humiliated, and they're not arrested because no drugs are found. Some, however, are arrested and convicted on drug possessions. Judging from what we see in Harris County, a fair number are innocent. A high proportion of those innocent defendants are black. A formal judgment of guilt for these black defendants are errors. Most black suspects are not selected for exploratory drug stops and searches, and for the arrests and convictions that sometimes follow. Because their behavior, they're deliberately subject to this costly, disturbing, and dangerous process, including the built-in risk of false convictions because of their race. Fabricated drug crimes and group exonerations. As we've seen, the most distinctive aspect of drug law enforcement is choice. Police officers get to choose their suspects in ordinary drug cases like in Harris County. James Simmons, in 2006, a black technology consultant, was arrested in Seattle by a deputy sheriff who testified at trial that Simmons, whom he subdued with a taser, confessed to selling the crack cocaine that the deputy seized for him. Simmons testified the deputy attacked him and planted the crack on him, sprinkled the crack on him, and that he never said that he sold it. Simmons was exonerated in 2010 after the deputy was fired for dishonest in reporting another drug arrest and made a few weeks after. See, they should actually lose their license. Police officers, they should get licensed. But most of the fabricated drug crime convictions that we know occur in large clusters. The registry maintained a list of 33 group exonerated that occurred across 28 years. The exoneration in this earliest group were complete in 96. At least 3 are ongoing. Altogether, these groups include more than 36,000 exonerated defendants, about 11 times the number of individuals exonerated in the registry. The groups are extremely variable in many respects, including the quality of information that is available to us, and they have common features. One, they have in all but a few of the groups, most of all the exonerated defendants were convicted of drug crimes. In every group for which we have information about the racial and ethnic identity of defendants, Black people and occasionally Hispanics are significantly overrepresented in many groups that are a great majority. The nature and number of great exonerations. LA, 99, 2000, the Rampart scandal. 99, authorities learned several years or longer, group of officers, the Rampart Division of LA, PD, had routinely lied in arrest reports and testimony and framed many innocent defendants by planting drugs on them and guns. On several occasions, they had shot and wounded unarmed suspects, then planted guns, sprinkled crack on them. Sprinkled the crack. Okay? Fucking idiots. In the aftermath of the scandal, more than 170 criminal defendants had their convictions vacated and dismissed by Los Angeles County judges. 99 and 00. Won't be going to LA. Majority of them were Hispanic men who were believed to be gang members. Almost all pled guilty to false felony drug or gun charges. Tulia, Texas, 03. 99, 2000, 35 defendants. Almost all of them are Black who were convicted of selling cocaine. Okay. In 03, all 35 defendants were pardoned by the governor after a judge investigated the cases and concluded that Coleman had engaged in blatant perjury and was the most devious law enforcement witness this court has witnessed. The investigation revealed that Coleman had charged the defendant with selling quantities of highly diluted cocaine that actually took from personal drug stash. So his own personal drug stash. The Rampart and Tulia group exonerations both include dozens of defendants who were convicted of possession of sell drugs. The Rampart scandal was wide-ranging criminal conspiracy, including at least 9 officers. They created a name called CRASH, the acronym for Community Response Against Street Hoodlums. The Rampart CRASH program was credited with reducing the high rate of gang-related crime in the neighborhood, but over time, CRASH crew itself devolved into a criminal gang. They continued to arrest suspects for legitimate crimes, including drug trafficking and illegal gun possession, but they also conducted illegal searches and lied about them, stole money, drugs from suspects, and sold drugs they had stolen. Shot some suspects, sold to others, planted drugs, and occasionally guns on suspects. Most of the suspects they searched, arrested, framed, and abused were Central American immigrants, usually undocumented. Many were deported before they were charged with crimes and may never have learned that their convictions could be challenged. The process that produced the exonerations we know about was confusing. It was chaotic. As a result, our information on Rampart exonerations was severely limited. Okay, so the 31 other groups that were listed in the group's registry were also extremely variable in many respects, by the number of cases and charges on which defendants were convicted, to the process, convictions, exonerations, to the quality of information of our disposal. For example, 2 of these groups involve forensic lab analysis in Massachusetts, whose misconduct led to dismissal of drug charges against 32,000 convicted defendants. One of them, dry labeled. Okay, dry labbed. Many of the cases wrote reports that they had seized materials or whatever the police suspected they were without benefit of chemical testing. The other forensic analysis systematically stole drugs from labs to feed their own multiple addictions. 17 groups were relevant in the report. Let's see what the table says. All right. So, where, when the exonerations took place? So you got New York City, 94 to 06, the Dirty 30, about 100 mostly drug cases, almost all were Black and Hispanic. New York officers conducted legal searches, stole money, took bribes from drug dealers and others, and planted drugs on some defendants. Philly, 95 to 97, 230, mostly drug cases, all Black. Wide range of police misconduct in 39th District. Elsewhere, including planting drugs. LA, Rampart, 170, many drugs, mostly Hispanic. LA police officers abused suspect gang members over 7 years, including planting drugs and weapons, and deported them. Oakland is like the brother city to Detroit, so shouts out to my Oakland brothers. Almost all Black, 75. This is from 2001, 75 mostly drug cases. Corrupt Oakland police officers known as the Riders planted drugs, falsified records, and beat defendants. Toledo, Texas, we just talked about. Louisville, Kentucky, 7 all drug cases. It's Black. Louisville is mostly Black city. 2 Metro Louisville police officers falsified searches warrants, planted drugs, and committed other crimes. Mansfield, Ohio, never heard of it. 19, mostly Black. Confidential informant gave fabricated information to a DEA agent who used it in the base for arrest warrants supported by perjury and falsified arrest records. Benton Harbor. Shouts out to where Sinbad is from, the comedian. Benton Harbor, Michigan. I know it's that bad out there. 65 mostly drug cases, all Black. 2 officers planted drugs, conducted illegal searches, and falsified arrests. Camden. I know Camden. I've been there. 70 mostly drug cases, almost all Black and some Hispanic. Police officers planted drug, falsified arrests, and committed perjury. Tulsa, Oklahoma. Okay, police officers and ATF agents fabricated evidence, planted drugs, falsified search warrants, and committed perjury and stole money. Philly, more than 1,100 mostly drug cases, and this is from 2013 to 2020. Officers fabricated evidence, planted drugs, robbed suspect dealers, and committed perjury and other misconduct. Philly, 2015 to 2020, more than 250 cases. Officers pled guilty, perjury, falsified search warrants, applications, and with colleagues fabricate evidence and planted drugs. East Cleveland, police officers, mostly Black, committed searches and seizures, violations, and tampered with witnesses. Chi-Town, the Watts Group, we already talked about them, 187, all Black. Sergeant Ronald Watts and his subordinates planted drugs, falsified arrest records, and testified falsely against defendants from Ida B. Wells Public Housing. I know somebody from Ida B. Wells Public Housing. I'm not going to say who they are. Played against them. Great athlete. Jackson County, Florida, 88, mostly drug charges. Sheriff deputy questionable traffic stops, planted drugs, fabricated evidence, and falsified records. In NYC, 2018, mostly Black and Hispanic, 453. Perjury charges off after video caught him fabricating evidence using drug arrests. All right. So here's a chart. So at least 2,975 drug exonerations, primarily Black. All right. The group registry is far from complete. We only began to conduct systematic searches for group exonerations a few years. Our resources are limited, and they are not easy to find. Study from a distance. Most do not receive national attention. Some barely make regional news. Beyond a story or 2 about corrupt officers, even local news coverage is often limited. We don't know how many group exonerations we have yet to find. Okay, so we're going to skip down. So we're going here. The Watts exonerations in Chicago, Chi-Town, are a variation of the things we saw in Rampart and Talia groups. Chi-Town, 16 to 22, the Watts groups for nearly a decade. Chicago Police Sergeant Ronald Watts directed a crew of officers who terrorized black residents in Ida B. Wells public housing development. They planted drugs, extorted thousands of dollars with threats of arrest and prison. In 12, Watson's subordinate, Khalat Muhammad, were caught on video stealing money from an FBI informant they believed was a drug dealer. In 13, they pled guilty to federal court and were sentenced to prison. After that, scores of complaints about behavior finally gained traction. The first exoneration in 2016 were cases of Clarissa Glenn and her husband, Ben Baker, who was framed twice, the second time after he filed a complaint with police department. 173 people were exonerated, 10 twice and 3 separate times. And many suspects of Watts' case resembled that of Rampart scandal. Unlike Rampart, our information on Watts scandal is excellent. So, all 183 Watts Group drug exonerations to this date are included in registry of individual exonerations. What's the impact of police misconduct? The legal system may sometimes treat routine drug convictions as a throwaway crime, but the consequences of fabricated convictions are hardly trivial. Two examples from the Watts in Chicago, largest most recent exonerations in the main registry, illustrate the range of penalties. February 6, Gregory Warren and several others were herded into a parking lot at I.B. Wells public housing development. Okay. Watts replied, "You'll see. Warren was handcuffed and searched. No drugs were found, but the officers took all the cash in Warren's wallet and drove him to the police station. And Watts pulled a bag of drugs from the drawer and said, 'These are yours.' Others officers used Warren's stolen money to buy Popeye's chicken, which they ate in front of him. In August 2007, Warren pled guilty and was sentenced to 2 years probation. It was exonerated in 2018. Marie Leaks was in an apartment in I.B. Wells. Sergeant Watts and other officers barged in, demanding information about drugs in the building. Leaks said she had no information. Watts said she was holding bags of drugs, pointed to Leaks. "These are hers." Next thing I knew, Leaks said, "I was in handcuffs taken to jail." That's rare that they get a woman. She must have actually complained a lot to police about other things. Who knows? But, it's messed up she got in the car. They usually don't do women. So that is unique. Okay, sentences imposed by courts are only part of the undeserved punishment meted out to many of these scandals. Some suspects were beaten, had property stolen, or both, including some who were never charged with crimes. For example, the initial investigation that led to the first Philadelphia group exoneration was instigated by an event in 91. The narcotics officer in Police Department 39 District arrested a black college student named Arthur Colbert. Over a period of 6 hours, they called him nigger, took him to an abandoned crack house where they beat him, took him to a precinct where they continued to beat him, held a little pistol to his head and threatened to kill him, broke into his apartment and searched it, and eventually released him after promising to kill him if they ever saw him again. Finally, the exception of misdemeanor conviction in New York, all these fabricated drug crimes south the exonerees with felony criminal records. Why did these scandals happen? We don't know what the motives of dishonest officers who framed these defendants were, but there are obviously a few obvious candidates. Some of the corrupt officers took bribes, stole money, drugs from real drug traffickers, and may have framed innocent defendants to deflect suspicion. Tom Coleman, for example, lost his job as a deputy sheriff and was indicted for theft in a different Texas county before he was hired as undercover agent in Talia. After the arrest, and they need to stop allowing these police officers to go to different departments. After the arrest, 46 people on fabricated drug charges, the Texas Department of Public Safety named him as a 1999 Outstanding Lawman of the Year. But most powerful reason that officers who carry out these outrageous focus on black people is simple. That's what they always do. Drug law enforcement in general bears much more heavily on black people than white, as we saw in Harris County. As any forger knows, the way you create conviction or convicting fakes, so a forger, is you make them look like the real thing. For drug cases, that means pursuing and arresting most black people. So if you pursue only black people, then guess what? They become the face of drugs. and drug laws and drug trafficking. Okay? You create the monster. Of many costs that the war on drug inflicts on Black community, the practice of deliberately charging innocent defendants with fabricated crimes may be the most shameful. We have no idea how often it really occurs. And I think this is it. So, yep. In conclusion, this is it. Exonerations provide a view of criminal cases from the past that we couldn't see when they happen. For murder, we see a high concentration of innocent Black defendants who were convicted in 80s and 90s. The scale of that problem seems to have been decreased for convictions in the past 20 years, along with sharp drop in the national murder rate after 95. It is hardly gone away. We know about many of those 20 to 40-year-old false murder convictions because of work of a handful of big city prosecutorial conviction integrity units. We can only hope that their offices and other prosecutors and police will learn from the past they uncovered to avoid similar injustices in the future. For rape, we see a dramatic change for the better. Many innocent defendants who were misidentified by rape victims and convicted in the 80s were exonerated by DNA evidence in decades since 89. The bulk were Black men who were accused of raping white women. 3 have been no DNA exonerations of misidentified. There have been no misidentified rape defendants who were convicted since 2008. Because DNA testing now routinely corrects misidentification before conviction, this extraordinary technology success has been preventing hundreds of false convictions, perhaps more, mostly of Black men. Let's hope that other technology and breakthroughs improve the accuracy of criminal investigations to similar degree. If so, there may also, in process, reduce the heavy, disproportionate impact of false convictions of Black people. For drug crimes, the picture is grim. Black and white Americans use illegal drugs at similar rates, but Black men are 19 times more likely to be convicted of drug crimes they didn't commit than white people. Most drug crime convictions occur in large clusters, which makes it impossible to identify temporal trends, but we see no identification that the huge disparity is waning. The cause of this extreme racial discrepancy are plain. Black people are much more likely than white people to be stopped and searched by officers who are trolling for drugs, which puts them at risk of false drug convictions based on factual errors. And Black people are a great majority of victims of police officers who will systematically fabricate evidence to frame innocent defendants for drug crimes. The solution is clear. Stop treating illicit drugs and illicit drug use primarily as a criminal problem. The war on drugs is heavily burdened on this country, but the worst costs are borne by Black people, Black men, and other people of color. If white people are stopped, searched, humiliated as often as Black men, would we even have a war on drugs? What if police across the country engage in methodical programs of planting drugs on innocent white people? It is hard to believe, and this is the end. So, a lot of people troll. And they go online, they'll troll. They'll troll people. Okay. But that is the worst trolling that you can get, is when you're racially profiled and harassed. All right. So you want to troll those that are actually trolling, and they can cause severe damage and harm to you. So what this shows is that there is a problem still. So you guys, my take on it is simple. I think police should be licensed, and just like an accountant, he has a CPA, stockbroker, he has a Series 7, a medical doctor, they passed the bar, medical bar, lawyer. Once he gets his Juris Doctorate, he doesn't have to go to the law school. He can actually go and just take the bar exam. He's licensed in the state. He has to do a certain amount of hours in order to maintain his license. An endocrinologist is licensed. A pathologist is licensed. Forensic pathologist is licensed and certified. Why can't they be licensed? If they commit a crime, they should actually be removed. They should have penalties levied against them. They should not be able to practice that profession at all. No matter, they can't go to another county. Now, hey, they want to go to Canada, they can go to Canada, and Canada wants to rehire them, they can. But The candidate will have to explain why they're hiring a person that lost their license to practice law. In law enforcement, same thing with lawyers that work in prosecutorial arms, that work in the criminal justice system. If a person comes up that is exonerated for falsified evidence or information that was withheld from the other side when the trial is actually going through, well, then they should lose their license. Same with the judge. They should be disbarred and lose their license. And that will cause a shift in false sentencing, mislabeling, and a lot of penalties that are levied against so-called black men once you actually start hitting them in the wallet. Once they see that they can't actually engage in tomfoolery and skullduggery, hey, you'll see the shift and a huge drop. And then you got to actually go after different corporations and companies. So you have insurance companies. They get reductions in insurance rates for police officers, firemen, things like that. Hit them too. You know, you want to make it hurt, you pull your money out of those different insurance agencies and things of that nature, car insurance, they give them reductions. Simple. And once they start saying, oh, I'm going to lose 5,000 or 10,000 or 100,000 black men that are driving on these roads that have car insurance through us, and we give discounts to, they'll probably stop giving discounts and it'll shift over to like 2 or 3 primary companies that insure them. Because it'll just be too much for them to lose 1 million or 2 million or 10,000 or 20,000 people. Okay. And then people who work in specific government jobs, as so-called black men, you have different life insurances. And they actually give reductions to life insurance policies, police and judges and lawyers and prosecutors, things like that. And, you know, go after that. So once they see that you're pulling your money out, because money talks, pull your money out the bank. Don't argue with these people because police aren't paid through taxes. They're paid banks. So you pull your money out the banks. And again, they have qualified immunity. Get rid of that. Troll. You want to get rid of that? You want to troll your representatives to get things changed? You go after the qualified immunity. Now, I get it. Some of those senators, House reps, they got it too. Some 3-letter organizations, like, you know, FBI and stuff like that, they have qualified immunity too. That's why when you had the case in Harris County and in Chicago where an FBI informant, well, not FBI informant, FBI agent that was actually selling undercover, and the police officers tried to steal money from him or her. You know, I'm not going to say it was a guy or a girl. It could have been a guy. They said, oh, no, he tried to take my money. He threatened to shoot me and all this other stuff, man. What's wrong with this guy? They said, oh, well, you know, this is what we do. Well, you're not going to do it anymore. So at the end of the day, you know, a lot of those House reps and senators, they don't want to get their qualified immunity removed. But at the end of the day, you know, hey, it's got to happen. So at the end of the day, brothers, I was supposed to do this a little bit earlier, but I had to get the workout in. I had to get some things taken care of first. So this is it. So this is the 2022. Let me see. The 2022 Race and Wrongful Convictions from the National Registry of Exonerations. So hope you guys enjoyed it. This is something for you to take. You can download this as an MP3. You can download this as an MP4. Okay. This way you'll have it and you have to sit through the long reading because it's only like 55, 60 pages. And mostly you want to go down and click the links and you want to save some of those different links to the different counties and the different things that have occurred in the different books, because there's a lot of links that I didn't go over that those books are essential. You want to keep those. Those studies are essential. You want to keep those. All right. So this is 2 hours and 30 minutes. So download part 1, download part 2. All right. Go through it, break it down, challenge some of the surveys and the different links and references and research and things like that. Use it for your videos, use it for your research, and make sure you save this on MP4 also for your children as a time stamp in history. All right. So, because they're not going to be putting out a lot of these reports to the public like that. And it's hard to find these reports. You have to donate, which I donate to the exoneration fund to get access to some of these things. So this does not come free, brothers. So drop some money, some coin to your local units that actually help with discovery for false convictions. Go find your cities. What is it called? CIUs. Go to exoneration funds. Donate to you have University of Michigan exoneration fund. You also have one in California. Okay, go online, drop some coin. It can help so many so-called black men that are falsely incarcerated. Thousands are in jail for false drug convictions, false murder, false rapes. Help them out. Some for false robberies. Help them out. And anything you can do can help. And let me see if I can find the number for you guys. Okay, let me scroll down. Okay, it's acting up. But you just go to the National Exoneration Fund and you'll be able to find it because it's acting funny right now. All right, bros, that's it. I'm out. Keep your heads up.